Record versus Harrison case number 23650.
Gary Gill on behalf of Mr. Brown.
For a final status conference here today, scheduled again on November 23rd. This would be the plea cutoff. Mr. Gill, and you talked to Mr. Harrison about.
I have talked to Mr. Harrison as well as Mr. Brown. They are going to go to trial.
Are the people ready to proceed?
Yes, Judge.
Mr. Harrison, you've been able to talk to your counsel about this?
Yes, sir.
Okay, and that's your that's how you want to go forward?
Yes, sir.
Okay, so we'll proceed with trial as scheduled on the morning of September 23rd. Roland, the people have submitted their instructions as well. Looks like it.
I believe so, Judge. I think they were some time ago.
Okay. All right, Mr. Rolla, are you anticipating any issues that are going to need to be addressed?
No, Your Honor.
Mr. Kilo?
None, Your Honor.
Okay. So I'll just ask counsel and Mr. Garrison to be here by 8:30 in the morning of September 23rd. And we'll begin the jury selection and trial at 8:30. Mr. Rolla, anything else that we need to address for the rest?
No, thank you, Your Honor.
Mr. Kilo?
No, Your Honor. Thank you.
Mr. Garrison, do you have any questions about how we can proceed?
Sir.
Okay, thank you. We'll see you on September 23rd. Versus Regina Pulaski, case number 246716. Counsel, put your appearances on.
Good afternoon, Your Honor. John Steffi of Harris Law on behalf of Ms. Pulaski.
Mr. Steffi, can you tell me the status of this case from defense perspective?
Yes, Judge, I can. This is our second status conference. Been working on trying to get a resolution. I have not received correspondence from the prosecutor in some time about this case. In fact, since the end of July. So I'm still hopeful that we can negotiate a resolution. We do not have one at this point in time. And that's pretty much where we stand on our end of it.
Are you anticipating new or different offers from people, or?
I'm optimistic, I should say, cautiously optimistic, but I can't tell you.
Mr. Rolla, is your offer going to change for any reason?
Well, Judge, as I indicated, Mr. Steffi, it's a week to 10 days ago, it's just a holiday, we're meeting the victim, I think tomorrow. I'm sorry, Monday, and that's the earliest that they could get to meet with us again. I'll contact his office again after I have that information.
I was trying to get a sense because, I mean, the case was found over in April. I mean, is anything going to change, or should we just set this to trial, I guess?
I was unaware that Mr. Rolla had reached out. I don't have an email from him, so I'm optimistic perhaps after he meets with the complaining witness's family, things might change. I'm fine setting a trial date if you want, and we can keep working at it as long as it's not a really quick trial date, I guess.
Yeah, all right. I think I'd like to do that given the status of the case. We'll set a plea cutoff date along with the trial date.
And I think that'd be appropriate.
Yeah, Mr. Rolla, how many days of trial?
That's what I'm looking at right now, Judge.
to witnesses.
Madam Judge, I see we have. We're gonna get a 3-day trial. Unfortunately. 1, 2, 3, 4, 5, 6, 7, 8, 9, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25 potential witnesses.
Stephanie, how many witnesses on your side that be different than prosecutors?
Probably 2 to 3.
I mean, just from the number, it sounds like we're gonna need more than 3 days.
Maybe, and Judge, again, I can't speak for what the defense is going to do. I don't think the court would be remiss in actually setting aside 5 days for this particular case as it exists right now.
Objection to that.
No, Your Honor, it's your docket.
So we'll set this for a 5-day jury trial. I'll set it about 120 days out. I will set this for a final status conference on the court's full motion day immediately prior to the trial date. That will be the plea cutoff, so counsel and Ms. West, to the extent there's further negotiations. That final status conference would be the last opportunity for the parties to reach an agreement following that date. We will proceed with trial. That will also be the cutoff for any motions, so council's free to file motions at any time during this 120-day period, but it must be filed and heard no later than the date of that final status conference. And then Mr. Steffi, just so that you and your client are aware, the court will send out the trial dates, notice of that, and along with that, we'll also get a notice of that final status conference. You'll know all of those dates at the same time, so that you can be prepared with your client.
Yes, Your Honor, thank you.
That's the cutoff. Mr. Rolla, any other scheduling matters that we can address for your side?
Not in this case, thank you.
Mr. Steffi.
Nothing on my end, but thank you.
Thank you. That's all for today.
Have a good day. I'll see you in a little bit, actually.
Okay.
Thank you.
Is Ms. Keys here? Ms. Keys, if you want to come up to the front, please. People versus Tiffany Keys, case number 246748. The record should reflect Ms. Keys is present here in the courtroom today. I could have counsel for your appearances on.
For the record, gentlemen, we've got people.
For the record, Your Honor, Gary Gilo on behalf of Mr. Brown.
Okay. Mr. Kilo, can you tell me the status of this file, please?
So we'd like to enter a plea today, Judge. I may, should be entering guilty plea to count 1, possession of marijuana, whatever that is. And count 3, operating while intoxicated under the influence of drugs. Count 2 and the habitual 3rd will be dismissed. And she also has an appointment scheduled for a capital service.
Okay. Mr. Rolla, is that a correct statement of the plea offer?
Because there were two offers, an alternative, 2 different police offers. I want to be sure. I'm just feeling, she's the name of which one?
Count 1, possession of Brazil or whatever that is. And count 3, operating intoxicated under the influence of drugs.
And that's correct, Judge. There's also 2 valid blood testing.
No objection.
Ms. Keys, have you had, excuse me, an opportunity to talk to your attorneys about this
Yes.
plea?
Yes, sir.
And what we said here today is that the same agreement that you discussed with them.
Yes, sir.
Is that how you're choosing to proceed today?
Yes, sir.
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Keys, are you currently on any kind of probation or parole?
No.
Okay. You understand that by pleading guilty to the possession charge, that's going to carry with it a maximum possible penalty of up to 2 years and or a $2,000 fine.
Yes, sir.
And that the operating while intoxicated charge carries with it a maximum possible penalty of up to 93 days and or a $500 fine. Do you understand that?
Yes, sir.
With those maximum possible penalties in mind, what is your plea to each of those charges today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial, to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all of those rights.
Yes, sir.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes.
Has anybody threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what you said here in court today?
No, sir.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you are guilty?
Yes.
So this happened quite a while ago, October 31st of 2021. Is that the correct day? On that day, were you here in Otsego County?
Yes.
And were you operating a vehicle on South Otsego Avenue here in Otsego County?
Yes, sir.
Prior to operating that vehicle, had you consumed some controlled substances?
Yes, sir.
And did those controlled substances affect or impair your ability to safely and reasonably normally operate that vehicle?
Yes, sir.
And was one of the substances alprazolam, or I think that's Xanax?
Yes.
Is that one of the substances?
Yes.
Okay. Did you have a prescription or any legal right to have that substance at that time? Mr. Rolla, are the people satisfied with the factual basis?
We are, Judge, but just as a procedural matter, I don't recall the court asking Ms. Keys to have any objection to Mr. Buell standing in place for Attorney Lucy Sneer on behalf of her.
Do you have any objection?
No, sir.
Very good, Your Honor, thank you. And yes, Your Honor, people are.
Thank you, Mr. Keel. As to the factual basis.
You can have a factual basis, right?
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Keel?
No, yeah, I think.
And are the people satisfied that the court has complied with statute and court rule in taking this plea?
As to accept this police request,
Mr. Keel? Thank you. Ms. Keys, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of those charges. The court will accept your guilty plea as to both. This matter will be set for a sentencing hearing. It's important that you stay in touch with your attorneys before that hearing. Before you leave today, you're going to meet with Mr. DeLeo from the probation department to set up the pre-sentence report. And that's all. Thank you.
Thank you, yeah.
Our next hearing is set for 2 o'clock. I don't see anybody else, so we'll take a short recess till 2 p.m. We have Mr. Van Blaricum.
Yes.
You're right there. Okay. Sir, if you come over to the podium, please. This is People versus Randy Van Blaricum, case number 246742. The record should reflect Mr. Van Blaricum is present here in the courtroom today. I'd like to have counsel for your appearances on.
Thank you, Your Honor, for that.
Your Honor, Gary Deal on behalf
Thank you. This is the date and time set for a sentencing hearing in this matter. Mr. Van Blaricum, if you had a chance to go through the pre-sentence report and speak with Mr. Gilo about that.
Yes.
Mr. Gilo, additions, deletions, or corrections that need to be made to the report.
Oh, yeah.
Are there any challenges to the scoring of the guide?
Oh, yeah.
Well, do the people have any additions? Corrections? Any challenges to the scoring of the guidelines? Anything on behalf of the people for allocation today?
Such the method case is the second call recommendations. 0 to 9 to 10 years will be a standard county sanction absent unusual circumstances.
Mr. Kilo, anything on behalf of Mr. Van Blaricum today?
I believe he has no prior criminal history. No probation was recommended in this case. I'd ask the court to consider the sentence.
Mr. Van Blaricum, anything that you wanted to say today?
To straighten out and fly right.
Okay.
I pray God every night. So.
All right. I did review the pre-sentence report. I'm familiar with circumstances that bring you before the court here today. Have an address here in Otsego County? Do you live here?
No, I'm staying with a friend in Mason.
Okay.
And I'm on probation in St. John's.
Okay.
I didn't board the 26th because they brought me here on the 26th. And when I get out of here, I got a court there. So I owe them $1,800.
Gotcha. Okay. So there's a hold on you for that other case.
I have another case in Lansing. I don't know if it's a hold or not. I'm just waiting to get out of here and then go to Lansing. At 9:30, I'm supposed to be there.
Okay. Okay. Understood. All right. I did read through the report, so I'm familiar with why you're before the court today.
Yeah.
The basis of the charge here. There's also a lot of information in that report about your background and history and so forth. You don't have an extensive criminal record there. You do have some previous convictions. They're drug related. This is clearly a circumstance where you're going to need to get some treatment for yourself. Otherwise, you're going to keep building up these charges, and your sentences are going to get more and more lengthy as we go. I think, given the circumstances here and your past record as it stands now, that a straight jail sanction is appropriate to address your conduct in this case, and a sentence within the guidelines be sufficient to accomplish that. The guidelines in this case are 0 to 9 months.
Yeah.
The court is going to sentence you to 4 months or 12 days in the Otsego County Jail. I think a sentence within the lower third of the guidelines is appropriate. You do have credit for 43 days served. The court is going to order payment of a crime victim's assessment in the amount of $130, court costs of $325, attorney fees of $350, and $68 state cost. You have the ability to seek an appeal of the sentence. Mr. Gill is going to provide you with some papers that explain to you what your appellate rights are, as well as how to request a court appointed lawyer to help you with that. Mr. Gill, now
Thank you.
Ms. Parent here? Ms. Parent, you want to come up to the podium, please? Versus Mandy's parents, case number 246750. The record should reflect all the parents present here in this courtroom today. I'd like to have counsel put your appearances on.
Record, Your Honor. Gary Delo on behalf of Mr.
Ms. Parent, Mr. Brown is your usual attorney. Do you have any objections to Mr. Gilo standing in for him today? Mr. Gilo, can you tell me the status of this case?
I can, Your Honor. Well, first of all, I'd like to tell you that she's got a misdemeanor case with this. There is a plea offer that Mr. Brown believes will likely result in a global resolution. So he's asking for 30-day adjournment.
Mr. Rolla, do you have any objection to that?
No, Mr. Brown's not here. There was a plea offer, and I think he came for the record. Was the plea to count one with the official limit being dropped and restitution goes to the employer.
So the other case that's in district court, is that a felony case? It's going to be found over.
Misdemeanor.
Judge.
Okay. All right. So the court will set this for a plea hearing in about 30 days. Mr. Rolla, anything else on this file today?
Not in this file, thank you.
Mr. Gilo?
No, Your Honor, thank you.
Ms. Parent, did you have any questions? Okay. Thank you. Just make sure that you stay in touch with your attorneys before the next.
I will.
Okay, thank you. People versus Matthew, case number 195787.
For the record, Your Honor, my phone.
Good afternoon, Your Honor. Fabiola Galguera on behalf of Mr. Matthew, who's present here with me at the court today.
Okay, you guys come right up to the podium, please. I think we set this for a status conference. I don't have the file back from appellate court yet.
The correct attorney is status call.
Yeah, okay. So Ms. Galguera, this case has been winding its way through the courts for many years. Can you tell me where things are at and how can we move forward to get this resolved from where it's at?
So we got the final order from the Court of Appeals. I believe that at this point, it's about sending this for trial.
Okay, all right. Mr. Rolla, can you tell me how many days of trial do you think we're going to?
Yes, at this court, and I realize it's been some time, but these are cases that were consolidated for trial. There are 18 witnesses for the prosecution. I'm going to anticipate we probably need 4 days for trial.
Your Honor, it was my understanding that you have ruled not to consolidate the cases. There was a motion regarding the information from one matter coming into the one that's going to be set for trial first. But insofar as the cases themselves, my understanding is that as of right now, they are not consolidated, they are separate.
Oh, there's a motion basically to have the evidence in regards to one case. Hearing this, it's while Ms. Galguera is correct, they were not technically consolidated for trial. The evidence in the one case, including the same witnesses, are going to be admissible in the other case.
Okay, but as it stands, we only need to set file number 5787 for trial. Correct.
No, I think, again, and I can't speak for the defense, I don't want to do that. But I believe, quite frankly, the resolution of the first trial will probably resolve pretty much everything in this particular.
It still doesn't answer my question, though.
No, you don't have to schedule the other matter for a trial.
Okay, great.
I apologize. I wasn't trying to be that. I just didn't want to presume to be answering for the defense.
So as to this file, you think 4 days, you said?
Well, Judge, and again, if there's 18 witnesses to get all of the evidence in, we might be able to get it in 3 days. I don't know what the defense is going to do or not do, which is why I said 4 days.
Ms. Galguera, how many days of trial?
Based on the witnesses we have previously submitted, I think we'll need 2 days of presentation for our case. So I think you probably should plan for either 5 full days or maybe splitting it between 2 weeks. I think, yeah, the original was weekend.
I'm gonna set this for a 5-day trial. And I'm gonna set it for the earliest possible date. And I can tell council to get 5 days in a row, it's gonna take a few months, so I think. If it's 90 to 120 days out, Ms. Calgary, is that enough time for you to be prepared to proceed?
Yes, Your Honor.
Mr. Roloff?
Yes, sir.
And the court, per its usual practice, will set this for a final status conference just prior to the trial date. Usually it's 2 or 3 weeks prior. To the extent that the parties are going to engage in any further different plea negotiations, that final status conference, one of the purposes of that is to use that as a plea cutoff. So the court would not accept any pleas after that date. That will also be a motion cutoff. So to the extent that either side has any more motions that need to be filed, they would need to be filed and heard no later than the date of that final status conference. The court will send out notice of the date of the trial and at the same time the date of that final status conference. So all parties will know the schedule going forward. There won't be any further hearings unless the parties schedule some type of motion hearing between now and that final status conference. Mr. Rolla, are there any additional dates that you need to address for scheduling?
Not for either of these two.
Ms. Calgary?
No, I do want to address one separate matter.
Sure.
Mr. Matthew just notified me of this outside of the court. So he has new employment. He has been gainfully employed the whole time he's been out, but right now he's employed with a company that works right out of Niles, Michigan, so right on the Indiana border, doing fiber optics installation. And there are some jobs that require just kind of coming right over the border into Indiana. I was wondering if we could, and of course, if the prosecutor doesn't object, have a modification to the bond conditions so that he may travel just across the border to Indiana for work. It's just purely for work.
Mr. Rolla, any objection to that?
Yes, Your Honor. This has been delayed for 4 years effectively. This matter goes back a long time. The charges are significant. And while I understand the defendant appeared here today, people have concern that if he crosses the state border, it may give him an incentive not to come back to the state.
Is there any, other than that, is there anything that you can articulate that supports?
Along with Judge, and again, I'm going to check and see if I have anything indicating otherwise as to his failure to appear in the past. Excuse me, Judge, this is pages of documents as this goes back to the next. I'm looking for the defendant's name. If memory serves me correctly, he had prior assault and domestic violence charges as well as SOAR violations. That's what I can't find right now. So I'm looking for a copy of the lien. I can't speak immediately right now to whether or not he's failed to appear in the past.
All right, so Mr. Matthew, in my view, has consistently appeared for hearings. He's retained counsel, which means he's got a financial stake in this. Ms. Calgara has been pursuing defense actively in this case. It's a very minor, in my view, modification to the bond in that it would be limited to work purposes only. So the court's going to grant the request. Ms. Calgara, I would ask that you prepare an order that just reflects the court is modifying the bond to allow Mr. Matthew. Mr. Matthew, what's your typical work schedule? You work Monday through Friday?
Yes, it would be, I just started this week, so it'd be 8 in the morning until anywhere between 5 and 8 in the evening. So, and that's Monday through Friday, weekends would be off typically.
Okay, so Ms. Calgara, the order should reflect the bond's modified to allow Mr. Matthew to be in the state of Indiana.
As far as I know, Indiana's in the border across it too.
If something changes, just let me know. So
Okay,
just.
so in the state of Indiana, between the hours of 8 a.m. and 8 p.m. Monday through Friday. And then submit that either into the 7-day rule or with the stipulation as a form only from Mr. Wolf.
And again, the defense counsel, again, no problem communicating before. She could forward it to me by email, and then I can approve it that way, and then she can come soon.
All right, Ms. Calgara, anything else I can address for your side? All right, okay. Thank you. The court will send out the notices of those dates and we'll go forward from there.
Thank you, Your Honor.
People versus Ronald Hartman, case number 246752. Mr. Hartman present. This matter was set for hearing at 2:15. It's now 2:27. Mr. Hartman's not present in the courtroom. Do you know if Mr. Brown's had any contact with Mr. Hartman?
He has not had any contact. His phone is disconnected. I guess this was found over on 8/1/2/14. He just received video evidence yesterday from the prosecutor's office. And that's about it.
It looks like Mr. Hartman waived the preliminary exam. There are no prior failure to appear. The court will set this for a show cause hearing. Status conference in 30 days. If Mr. Hartman fails to appear at that time, the court will issue a bench warrant for his arrest.
Thank you, Judge.
Mr. Roll, anything on that file? I'm sorry.
No, Your Honor, that's fine.
Mr. Legal, is Mr. Black here?
I don't see him right now, Your Honor. He was just at my office, so I.
Okay. We're a little bit ahead of schedule. Let's take a short recess. We'll come back up. Okay, we're on the record in People versus Guy Black, case number 246682. If I get counsel for your appearance on, please.
Kyle Little on behalf of Guy Black.
Record should reflect that Mr. Black is present here in the courtroom today. This is the date and time set for sentencing in this matter. And Mr. Black, have you had an opportunity to go through the pre-sentence report and talk to Mr. Legal about that?
Yes, Your Honor.
And Mr. Legal, are there any additions, deletions, or corrections to that report?
Yeah, I don't know if the courts is inclined or can change the prior PSI, but I know that was provided as factual background. In that report, it just indicated in his substance abuse history that he did inpatient at Flint Odyssey House for 1 month. It was actually a 3-month program. He started in December and completed it in March of 2024. So that was a 3-month inpatient, not a 1 month. I did provide that verification to Mr. Rolla previously during our plea negotiations. I don't think he would have an objection and would acknowledge that that was the case for his prior substance abuse treatment.
All right, even though that is part of an attachment, I do think it should reflect accurate information. So, Mr. Rolla, do you have any objection to that? No. Okay, so the court will order that change be made.
Thank you.
Any other additions, deletions, or corrections?
No, you're not.
Are there any challenges to the scoring of the guidance?
No, you're not.
Mr. Rolla, do the people have any additions, deletions, or corrections?
Additions, deletions, corrections and value report, or challenges as to that.
Anything on behalf of the people for allocation?
Yes, as in I'm going to acknowledge, by the way, defense counsel to provide our office, in person, the short time for this hearing, obviously some documents. Regards to treatment and defendant underwent. In any case, this is a situation where the defendant made threats to the CI and the CI's family. And the recommendation in this case is 3 to 5 years up to 20 years with 2 days credit with restitution for same for $50. As a 5th felony, an individual who, quite frankly, his long history of controlled substance goes all the way back to 1999. I think that recommendation is appropriate. We'd ask the court to follow.
Mr. Legal, anything on behalf of Mr. Black?
Yes, Your Honor. Just kind of a timeline of the case. You know, as the court knows from the report, this offense itself occurred in November of 2022. That was right after Mr. Black had lost a brother. He was in the Gaylord area. A person that he used to use with contacted him, asked if she could get some methamphetamine. He agreed to sell her some methamphetamine. I know the report indicates that the initial discussion was 3.5 grams. The actual sale is 0.5 gram. Mr. Black disputes that he ever told her he had 3.5 grams to sell. But this case was about 0.5 gram of methamphetamine that was sold for $50 in November of 2022. Looks like the warrant itself was not issued until June of 23. In October of 23, then, almost a year later, he's arrested in Acosta County. He's been sentenced on that charge. In that case, there was a search warrant for his house. It was searched. They found some weapons and they found some methamphetamine, but it was only residue. It was residue in a bowl and residue in a straw. So in that case, he pled and was sentenced in May of this year. He was given jail time, 1 year jail time, 6 months up front, and then 6 months held over his head and 2 years of probation. He completed that jail time in August. But pending that charge and that sentencing, he did go, as indicated, to the Flint Odyssey House for 3 months from December to March. After that, he went to a sober living for a month. After that sober living, he then went in and started some counseling at 1016 Recovery Network. And that counseling was short-lived because he then had his sentencing in Acosta County. After he got out of jail, he went to AA. He actually got employment. He did some testing and took it upon himself to get accepted into a potential welding program. So he didn't sit at home in that last month and a half and, wallow and do nothing, thinking about, poor him, poor me for what I put myself in. But he tried to do things to better his life and continue to work on his recovery. And really his actions since that arrest in October of 2023 in Acosta have shown that he is committed to his recovery. And I think he will speak to some of that also. I I understand that he certainly does not have a great record, but I'd ask the court to consider to look at what he's done since this case came to fruition and when he got arrested on this matter, what his behavior has been like. And the fact that the situation of the case, he sold a half gram to someone that he knew as a user at a time when he was in a bad spot. And when they came to, she brought a undercover officer with her. Mr. Black didn't even have a scale to weigh it out, so they used the scale that the officer had. And then when his house is raided in October, all he has is residue. I think that shows that he's not a large seller of methamphetamine. He, as his record indicates, has a huge addiction problem, has had it for a long time, and has finally really taken the steps to address that. But he was not someone that was really out, selling methamphetamine all over the community. And if he was, I would wonder why, he did this in November, the warrant's not issued until June. And then there's no attempts to even arrest him. He doesn't come into the court system until the situation in the cost account. Which again does not look good because obviously you had the methamphetamine, but it was residue to indicate that he is a user, not a chronic seller. He is on probation now in Costa County with that 10-year max. He has a 2-year term of probation there. This is a 20-year max offense here. Given what he's done since this case happened, we would ask the court to consider a term of probation for Mr. Black. I think given his actions and what really happened in this case, I don't think that's an unreasonable ask. So we would ask the court to consider that, given that he's made the steps he's made, and continue to allow him to work on his recovery. If the court is not inclined to do that, we would ask the court to consider county jail time in lieu of prison, again, just given the steps that he's made. But lastly, if the court is considering staying within the guidelines and following a recommendation, we would ask the court not to impose more than 36 months of jail time. I think Mr. Black is a great candidate for the boot camp program. He's shown during this time frame what he can do and what he has done. So any sentence that exceeds 36 months would not allow him in boot camp. And then if the court does go that route, we would ask for indication that there is no objection to the boot camp. I do have a couple documents as indicated, one showing all the AA that he attended after he got out of the recovery and then after he got out of jail, as well as a letter from his employer, and then a letter from the institute that he was accepted into to start a loan program. I know Mr. Black would like to make a comment also.
Okay, Mr. Black, before I hear from you, I don't think this take a look at this. Mr. Legal, did you want these attached to the PSI?
Yes, sir. Thank you.
Mr. Black, is there anything that you want to say today?
Yes, Your Honor. The incident on November 3rd, 2022 is the reason that I'm here today. 3 days before, on October 30th, 2022, my only sibling, my brother, Steve Black, suddenly passed away from an anaphylactic shock as a result from a peanut allergy. I use this as an excuse to drink and use drugs daily again. Today, I know that whether I'm intoxicated or not, I'm responsible for my actions. From October 2022 to October 3rd, 2023, I continued to drink and use drugs daily, continuing to destroy myself and my life. On October 3rd, 2023, I was arrested at my home. Within 4 days of being in jail, I was coming to terms that everything needed to change, and I did not know how. I started going to AA in jail and listened to what was said. I decided to find a rehab and try to get help. On November 30th, with help from my mother, I was able to post bond and go to treatment. The rehab facility that I chose was Flint Odyssey House. This rehab is a dual addiction facility that dealt with my substance abuse, as well as behavior and complex trauma. It was a modified therapeutic community combined with counseling and substance use disorder classes. I stayed there from December 1st, 2023 to March 7th, 2024. I then went home 1 week awaiting a sober living house in Grand Rapids. I stayed at the Comfort Homes Sober House from March 14th to April 14th, 2024, where I immersed myself in the recovery community in Grand Rapids, going to meetings and therapy every day, sometimes twice a day. This is when I realized that I was really living what I had planned. On May 20th, 2024, I was sentenced to jail in Mecosta County until August 10th, 2024. I continued my recovery in jail. I was then granted the only outside maintenance trustee position for my final 3 weeks. After being released from jail, I continued to go to meetings almost daily and found a sponsor and started working the steps. I also have a part-time job with SRT Services, which is a maintenance company for an Airbnbs in the area. I found and interviewed for a private welding institute called the Mural Institute. This is a 12-week program that once I'm finished, I'll have 4 nationally accredited welding certificates with the possibility of an in-house career starting immediately upon completion. I'm 338 days sober. I feel good about my life choices today. My son is living with me for the first time in our lives, and things are going pretty good. I'm continuing to go to meetings and embrace the recovery daily. This sentencing is one of my final steps to start to leave that old way of dying in the past. I hope to be able to start my schooling on September 20th and continue making the right choices in my life. Continuous improvement is my only goal today. Thank you.
All right, thank you. I did read through the pre-sentence report, Mr. Black, so I'm familiar with the circumstances of this charge here in this case. There's also a lot of information in that report about you and your background and history and so forth. And I read over all of that. And in determining what's an appropriate sentence, I look at all of that information along with what the lawyers here have had to say and what you've had to say yourself. Based on what Mr. Legal provided to me and what you've had to say, it does sound like you've made some strides in terms of dealing with your underlying substance abuse and why that's occurring. And that's obviously going to be important for you going forward. And maintaining that, regardless of what happens with this case, is going to be a key for you because, as you well know, and as your record reflects, every mistake from here on forward, there's really not going to be any room for that anymore, and there really isn't even at this point, because we've been on probation many times and many different jail sentences, and you know what your conviction history is, and so any mistakes that you make going forward, all of those things are going to follow you, and you're going to continue to make the consequences more and more severe. So now is the time to do that. Looking at your past history and circumstances here, what you're asking for and your counsel's asking for is the court to make a significant departure downward, a 24-month departure downward from the low end of the sentencing guidelines here. And while you have made strides, there isn't anything that would justify such a drastic downward departure in this case. However, I think there are other mechanisms available, and your attorney mentioned one of those, which is the boot camp program. I don't have an objection to participating in that. I think given the progress so far that is a mechanism for you to have the opportunity to continue with that, in a different way through the Department of Corrections program. But at this point, given your history, given the guidelines, I think a Department of Corrections sanction is warranted, although again, I'm not gonna have an objection to you participating in the boot camp program. And I think it's appropriate to give that opportunity, given that this was your first Department of Corrections sanction. So the court is going to sentence you at the low end of the guidelines, which is 36 months to 20 years in the Michigan Department of Corrections. You do have credit for 2 days. Or again, for the record, although the Department of Corrections will send me a form, which I will indicate that I don't object to you participating. But to the extent that needs to be made for the record, I don't object to it. The court is going to order restitution in the amount of $50 that's payable to the Otsego County Clerk to be dispersed to straight area narcotics, crime victims assessment of $130, court costs of $325, state cost of $68. You do have the ability to seek an appeal of the sentence, and Mr. Legal, if you can provide or have Mr. Black acknowledge receipt of rights.
Your Honor, Mr. Black has received his appellate rights and has signed a receipt as his copy.
Good luck to you going forward.
Thank you, Your Honor.
Or go back. So hold on. Let me let them know that this is the next matter is People versus Jennifer Freeman, case number 226336.
The records are in that program.
Ms. Freeman is here. She's being brought up. Ms. Freeman, I'm going to have you go right to the podium there, please. The record should reflect that Ms. Freeman is present here in the courtroom today. We're on the record today in this case for resentencing. The court made some adjustments following hearing to the guidelines, which are now correctly scored at 24 to 40 months. The record should reflect that Ms. Freeman is present here in the courtroom in person today. If I get counsel to
People.
Thank you, Your Honor. Stephen Helton of the State Appellate Defender Office on behalf of Jennifer Freeman.
And Mr. Helton, I'm in receipt of an updated report reflecting new jail credit and so forth. Did you get a chance to review that?
I have, and Ms. Freeman and I noted that together, and we have no corrections to that.
Do you have any other corrections, additions, or deletions?
We do not. We do not.
And any further scoring challenges?
No, Your Honor.
Mr. Rolla, do people have any corrections?
No, Your Honor, thank you.
Any scoring challenges from people?
No, Your Honor.
Anything on behalf of people for allocation?
Again, there's a recommendation that changes the sentencing guidelines from 4.25 to 20 down to 3.5 to 20. The sentence imposed originally was still within that. It's still within the situation. Thank you.
Thank you, Mr. Helton.
Yes, I just mainly like to thank the court and its staff for helping to arrange Ms. Freeman's appearance here. I know it's meant a tremendous amount to her and to her family to be able to be present physically for this today. I mainly just want to let Ms. Freeman address the court. But I would like to share two impressions, two observations I've had since first meeting with Freeman in May. And number one hasn't changed. It's the fact that she has a tremendous amount of family support, and she's 100% focused on being with her mother who has cancer as soon as possible. And the support she has come through just based on numerous calls from several names of people who I can't even recall at this moment, asking about her motion hearing and her resentencing and what they need to do to be here and what they can do. And number two, which has changed, is Ms. Freeman's gradual recognition of just how serious drug addiction is, and the fact that it is something she's going to have to struggle with and work on and work through for the rest of her life. Ms. Freeman's admitted her guilt from day one. She waived her prelim and pled guilty at the very first hearing in this case. Her guidelines were 51 to 85 months. The court imposed a 51-month minimum sentence. We would just ask the court to impose a minimum sentence no greater than 36 months. This would allow Ms. Freeman, with your honor's permission, to qualify for SAA boot camp. And it would also, if she is unable to participate or complete that program, it would allow the parole board to determine whether or not she's a worthy candidate for early release, and also ensure that she has oversight through the parole board and through my organization, State Appellate Defender Office, to the resources she needs to succeed while continuing this journey. So we thank the court for its time and consideration and appreciate it.
Ms. Freeman, anything that you wanted to say?
Yes, yes. I just want to say, Your Honor, coming to prison, it has been a rough sit down in my life. I never took the time to stop and think about my actions or consequences resulting from my actions, but this day definitely got me thinking. The fact of having to stay in prison with many unruly inmates and having no control of my own schedule, having to depend on staff for everything, made me realize I need to change. Some things that made me in my life before this actually become my life, because life is not for me. I decided to spend my time keeping busy to distract myself from the violence and from the addicts in here. I found several women that have helped me stay sober, mentoring me through the hard parts of recovery. I found a great therapist provided by MDOC that had also spent time with me through my state to help deal with things that were out of my control and encouraged me in healing. I've been sober a little over 3 years now, and once I started the MAP program, it had become easier to fight the battle of my addiction. I finished my core groups, ASAT and Moving On, that were suggested by MDOC. They really helped, and I thank you for your support in my sobriety efforts to make sure I was mentally ready. I also took a few non-required groups offered to me, such as Real Life Recovery, Parenting from Prison, WHAM, NA, Chance for Life. From sliding downward within myself, also within my community, I wanted to make sure I had the coping skills to further my sobriety. Outside these gates, I wanted to be ready for anything that pops up out of my control. I wish I had the strength in my past that I have now, so I could have avoided the long battle of addiction, if not only put myself in danger, but also my community. This time here was a blessing to my life, saving me from what could have been the death of me. Once I became clean, I could just feel the change in my health. That in itself was a great motivator to staying sober. I didn't realize how damaging the drugs really made me feel. I feel relieved. Since I have been here, I have learned that time doesn't create change. Change comes from motivation. You have in achieving that change. I spent just as much time as some of these other women, and it's sad to see that some of them just haven't been able to fight their own battle with addiction. I keep my distance from them now, but I see them differently than what I used to. It disgusts me to know that I was once in their shoes, struggling the same battle. I pray for them every day. I ask for this chance to get time reduced, time served. When I am released, I have a plan on where I would like to go and things I would like to further my sobriety outside of prison. I would like to continue therapy with a recovery coach and continue attending a rehab therapy. I've made sure to plan out any necessary services that can help me with returning to society successfully, because I never know what tomorrow may bring. I have prepared myself for everything to keep myself organized so I can limit my stress that may trigger these old setbacks. I made a relapse prevention plan that has carried me through my stay here. I wanted and need to say sorry to my community, my friends, my family, for putting them through so much stress of having to deal with me. My mom has been in the hospital clinging to her life, and I don't want to miss a chance to show her the new me she wished to see so much sooner. And I want to show my kids that I can be there for them. I want them to never have to deal with the dirty cycle of my addiction ever taking hold of my attention again. They all need me to be sober for them, for they will be grieving the loss of their Nana when the time comes. In conclusion, this is the biggest reason I have fought so hard to stay sober. I wish to be there for my family. I love and miss them very much. And it's been a long journey. And I want to say thank you to my family for all showing up here and taking the time out of their day. Thank you.
All right, thank you. I did read through the original report to refamiliarize myself with the facts of your case. Of course, I do the update. I take all of that into consideration along with what the attorneys have said here today. The court has to recognize the new guidelines as they stand from 24 to 40 months. I thought the original sentence was appropriate under those guidelines, but the court recognizes that sentence was outside of the current guidelines. And under the facts of this case, I don't find that there's sufficient cause justification for the court to sentence outside of the guidelines, even though at the time of the original sentence, again, under those guidelines, I thought it was appropriate. Given the circumstances here now and the current guidelines, the court finds that a sentence within those guidelines is appropriate. So the court is going to sentence you to a period of 36 months to 20 years in the Michigan Department of Corrections. You do now have 862 days of credit. The court is going to preserve any of the fines and costs that were assessed at sentencing and any remaining balances. Because this is a new sentence, you do have the ability to seek an appeal, and Mr. Helton, you can have your client acknowledge receipt.
Thank you. And Ms. Freeman is going to acknowledge receipt and also fill it in and request counsel today. So.
All right, good luck to you going forward, Mr.
Thank you very much. Should be good.
Versus Frederick James Hess, case number 226346. Daniel, you're here on behalf of Mr. Hess today?
That is correct, Your Honor.
From the defense side, can you tell me the status of this case?
Yes, Your Honor, for the defense side, that there was an application filed in the Court of Appeals. Understanding that's been denied, but now there's an application pending with the Michigan Supreme Court, waiting for a date on that. Additionally, also, Forensic Center contacted Mr. Jockins and he confirmed with them that he wishes for the criminal responsibility evaluation to still be conducted. So, Ms. Caitlin Barber from the Department of Tech from the Forensic Center contacted Mr. Jockins regarding that, and he again confirmed that we want the evaluation to be completed. So we're waiting for the results of that at this point in time, Your Honor.
What are you asking the court to do for today's purposes?
Today's purpose, Your Honor, asking the court to basically wait and see until we get the forensic report, and also and wait until we see what happens with the Michigan Supreme Court appeal. Michigan Supreme Court is the application to it. So I asked the court to consider setting this at the beginning of the year and seeing where we're at with that, so we can proceed knowing how the case is going to evolve.
This matter has been stated, May 5th, 2022. Some alleged delivery of court uncertain. This matter has been delayed through interlocutory appeal, and while I understand defendants have the rights to have the constitutional rights, as indicated already on the record, this last appeal was just rejected, as was apparently the one before that. I don't know what's going on in the Michigan Supreme Court. I can't comment to that. And as to any request for any psychological evaluation, I don't have any information. But again, I don't think we should just automatically just push this off now for another 3 months just to wait and see. Justice delays justice denied, the people also have the right to trial.
All right, I am gonna get this on the trial docket. I have no idea what the Supreme Court may or may not do, but given the process so far in appellate courts, I'm not gonna hold up trial in this case on the off chance that somehow the Supreme Court's gonna grant when the lower appellate courts have not. And this case was bound over in 2022. I'm also rather familiar with the facts of this case based on prior motion practice. And I'm not sure what the basis of the questioning of criminal responsibility is. Are you going to pursue some type of insanity defense that Mr. Hess?
Well, we're waiting to see what the results of the evaluation, Your Honor, to dictate how we can proceed.
Yeah, but I mean, you got to have some kind of theory to seek evaluation for criminal responsibility.
Well, that would be the theory, Your Honor. I mean, insanity defense, yes, but we're waiting for the results.
So based on his intoxication of substances or just his general mental state at the time?
I guess all the above. Additionally, I do, for the court's information, I do have, a letter from the Department of Forensic Center regarding that, in case anybody's, questioning that. Again, we're just asking that the state of proceedings be continued to hear from the Supreme Court.
Okay, well, again, I'm going to docket this for trial. I'll build in time for the parties to continue to pursue the appeal and then insanity defense that you may wish for other diminished capacity defense that you want to pursue. But again, this has been pending since 2022. These are all things that could have been, at least with regard to the diminished mental capacity defense, certainly could have been pursued well before now. So, Mr. Rolla, how many days of trial do you think?
There's 16 witnesses, Judge, including live witnesses, so it's probably going to be a 3-day trial, I would imagine. 2 days for the prosecution and additional time for whatever the defense may choose to present.
Mr. Daniel, 3 days, do you think there would be enough time for trial in this case?
Your Honor, Mr. Jockins would probably be better able to address that question. I think at least 3 days of trial would be a correct assessment.
Okay, so I'm going to set it for a 3-day jury trial at about 120 days out. I will set it for a final status conference on the motion day immediately prior to the trial date. That will act as the plea cutoff and motion cutoff to the extent that either side has any motions to file. Mr. Rolla, any other scheduling dates that I can address for your side? Mr. Daniel, any further scheduling dates?
At this time, Mayor, thank you.
So the court will send out a notice of the trial dates. Along with that, there will also be a notice of the final status conference. The court won't set any further hearings until that time unless either side files any type of motion. But other than that, the next hearing date will be the final status conference. And the court will send out those dates that I indicated. That's all for today. Thank you.
Thank you.
People versus Baird, case number 236601. I could have you guys come up to the podium, Mr. Baird, right to the podium there.
Good afternoon, Your Honor. Tyler Belo, P75702 on behalf of Michael Baird.
Thank you. This is the date and time set for a sentencing hearing. I did receive your memorandum, Mr. Beal. I had a chance to review that prior to the hearing today.
Thank you, Your Honor.
I know you also did file a motion to adjourn the date today.
Right.
It wasn't something you could get on the docket prior to the hearing. Is that something that you still wish to address here on the record today?
Yes, Your Honor. My client is working full-time. His work is mostly seasonal, and so the work slows down around the December time period, and it picks up around the end of April and May. And so based on the recommendation, it would make a lot of sense to delay this sentencing until December so that my client can maintain employment. He has a really good job as an excavator. And so he works at a smaller company, and his company needs him there daily. They would sorely miss him if he was gone now or at a time during their busy season.
Mr. Rolla, do people take any position on that request?
Again, that's discretionary with the court if you wish to do it. Today is the time to date for sentencing. And as far as a request for delay, I know it's usually the court's policy not to grant delays for sentencing. This quote, times where a person appears for sentencing, they know the consequences that may be imposed by the court in sentencing, and they should be prepared to address those issues.
So, Mr. Belo, with regard to that request, we're going to proceed with sentencing today. I intend to impose a term of probation as well as jail time. But it was the court's intention to hold jail time in abeyance. So I don't think there's an issue.
There's not.
Forward.
Oh, so, sure.
All right. So we'll proceed with sentencing today. Have you had a chance to go through the pre-sentence report and talk to Mr. Fair?
I have, Your Honor. I've discussed that with my client. We have no additions, corrections, or deletions.
All right. Do you have any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Rolla, do the people have any additions, deletions, or corrections?
No, Your Honor.
Do you have any challenges to the scoring of the guidelines?
No, Judge.
Anything on that?
This is a front driving third situation. There's a recommendation of probation for 3 years. Blood alcohol was payment of 0.496. This to holding jail time in advance, obviously, the court's well aware for drunk driving offenses. After the first offense, our legislature has imposed certain minimum amounts of sentence, and we ask the court to follow that circumstance.
Yes, thank you, Your Honor. I've read my sentencing memorandum, but I would just like to briefly point out that my client's previous OWIs were from 2002 and 2005. So he has been able to drink responsibly for 18 years now. Since that time in 2023, when he was arrested, he hasn't had a drop of alcohol since. And so he has been able to quit on his own. I've had conversations with my client, and we've talked, and he is dedicated to never drinking again for the rest of his life. And so this isn't going to be an issue for him. I briefly pointed out that his 2 felonies that bump up his score were due to a traffic accident He was found guilty of reckless driving and he was eating lunch and wasn't paying attention admittedly, but it was nothing nefarious and it certainly didn't involve any alcohol or drugs. And so I believe with my client's record and with this new thing, with this new charge conviction, that he would do very well under term of probation to make sure that he does what he's supposed to do, gets the treatment that he needs, and continues on his life in the manner that he has mostly lived it.
Mr. Barrett, anything that you wanted to say?
Well, I just had some things. I have been sober for many, many years after, and then when I found out I was gonna have to get a divorce, or we were getting a divorce, it kind of relapsed on me. And I had a bout of, my wife and I both didn't drink. In fact, she's here today to support me and we're getting a divorce. Yeah, I screwed up really, really bad. And I'm drinking anymore. The accident was an unfortunate that I had, it was at 2015, very unfortunate. Someone was killed and then there was some serious injuries. And like I say, I was at work driving a truck and I made a mistake and caused that. So I don't know what else to say. I don't want to end up here again.
All right. So I'm obviously familiar with the facts of this case. I presided over the trial. I heard all the evidence that was presented. So I'm familiar with what brings you before the court today for sentencing. I'm also familiar with your prior history based on the information that was contained within the report. And I'm sure Mr. Reveal has told you and you've seen for yourself that the guidelines in this case call for up to almost 3 years in prison at the high end. Given the circumstances of this offense, I don't think that's appropriate. I don't think there are enough aggravating circumstances here to warrant a prison sentence. But what I do agree with, particularly in the recommendation, is the long-term probation. I think it's important that you're subject to supervision for a period of time to make sure that you're not engaging in driving with alcohol. And I think a long-term of probation is going to give the court and the community some assurance that you're going to be monitored and that you're not going to have the opportunity to do that. And if you do, and you violate probation, then the court's going to have at its disposal significant sanctions up to prison time. So to the extent that you want to avoid that as a consequence in this case, it's in your best interest to make sure you comply with all the terms and conditions of probation. I am going to impose a significant term of jail, but hold that in abeyance outside of the statutorily required 30 days in jail. And again, because I'm holding that in abeyance, and Mr. Reveal can explain that to you more fully, but that's a penalty that I can impose immediately without any hearings, without anything. I'm apprised of the fact that you violated probation in any way, and then that's in addition to any penalties that I can impose for violating probation. So there's going to be significant incarceration for any kind of problems that you have while you're on probation. So I want you to understand that up front. The court is going to, as I said, impose 12 months in the Otsego County Jail. You have credit for 1 day served. The court's going to order that you serve 30 days of that beginning on December 1st. So you'll need to report to the jail on December 1st by 9 a.m. Begin serving that 30-day sentence. Again, you have credit for 1 day served. The court will hold the remaining time in abeyance to be served at the discretion of the court. The court is going to place you on probation for a period of 36 months. The court is going to adopt as the conditions of that probation all the terms and conditions listed in the report, which your probation agent will go through with you. But of course, that includes, most importantly, that you not use or possess any alcoholic beverages or intoxicants. The court is going to order that you pay a crime victims assessment of $130, that you pay a supervision fee of $30 per month while you're on probation, court costs of $325. State costs of $68. By all testing reimbursement of $200, fine of $500. You have the ability, I'm sorry, and that's all as to the operating while intoxicated offense. As to the operating suspended license, $50 state cost. 30 days in the Otsego County Jail, credit for 1 day served, to be served concurrent with the sentence on the previous charge. The open container, also $50 state cost, also a 30-day sentence in the Otsego County Jail, 1 day credit, again concurrent, and then served at the same time as by charge. You have the ability to seek an appeal of the sentence. Mr. Velo, if you can have Mr. Baird now. Mr. Baird, meet with Mr. DeLeo here before you leave court, or does he need to contact someone else, Mr. DeLeo, about his probation?
I'll contact you.
Okay. All right, so Mr. Baird, make sure that you follow up on that. Also, again, it's very important that you report to jail on December 1st to serve that 30-day sentence. If you fail to report, the court will issue a bench warrant for your arrest. And again, the court can impose any or all of that 12 months. So if you have any questions about that, contact the court.
What time should you report, Your Honor?
9 a.m.
9 a.m. Thank you.
Okay. Thank you, that's all.
Thank you, Your Honor. Thank you.
He went to the district court. He's on his way here.
Take a short recess.
Yeah, yeah.
We're on the record and People versus Cole, case number 246749.
Thank you, Judge. John Steppe from Harris Law on behalf of Mr. Benoist Cole, present before your honor.
Steppe, can you tell me the status of this file here today?
Thank you, Judge. This is our first conference in front of your honor after bind over. An offer was extended. You're generally speaking wishing to accept that. However, Mr. Cole has a new case, which I discussed with Mr. Rolla before your honor came out. So I need to talk to his counsel on that case before I can enter a plea on this case. I've reached out to that assigned counsel. I'm not familiar with him, but I emailed him. So I would like to ask for potentially a plea date, so I can talk to the other attorney, but also have him enough time to review the evidence on it.
That outside of this jurisdiction?
No, it's in your district court here.
Oh, got it. Is it a felony charge?
It's resisting and obstructing and misdemeanor.
Judge, I can provide some additional information. It's a two-count police officer resistance. Alleged to have occurred on August 12, 2024. The defendant, in fact, had a hearing in district court today, and a full-day examination of his schedule.
Okay. Do you know who the attorney is in that case?
I can tell you that in a moment, Judge.
The reason why I ask is we need to wait to see if that's going to get bound over, so we can set both files together here at circuit court, or that's a fair question.
And I can answer the board's question. Mr. Attorney, Jonathan R. Baber, attorney for defendant, on open line.
He's a court appointed. He's on the court appointed contract now.
Oh, yes.
He is now. It's a new court appointed attorney. Judge.
And that prelim set for,
I think it's the 19th. If you give me a moment, I'll verify that as well.
but mid-September.
Yes.
Okay. So, yeah.
Yes, just for examination, September 19th.
Okay, so is that when we get that line over? Prior to that for motion day?
It's hard to say. Usually, sometimes it's hard to say.
But what I'll do, counsel, for both of you, I do have like a half motion day mid-month, so I'm gonna set this for mid-October. Half motion day, and the court, if that other file's bound over, then the court will set both files together for a plea hearing. That should be adequate time, and then for the objection, that's your step.
No, Your Honor, thank you.
Mr. Rolla, do you have any objection to that?
No, Judge, I think that'd be
Mr. Steffi, anything else we need to address for your side?
No, Judge, thank you, though.
Mr. Rolla.
No, Your Honor, not this time. Thank you.
Mr. Cole, it's just important that you stay in contact with both your attorneys so that you're ready to go forward at the next day, okay? Yes, sir. Thank you.
Thank you, Judge. Have a great day.
Help yourself.
Okay, so I hit enter.
Did you guys have a deal case?
That's kind of different.
Yeah, Benji.
Yeah, nice.
Do you have it?
I think
Oh, you already did.
yeah, I didn't need it.
Yeah, I got that now.
Yeah.
Nice to meet you.
Okay, so I'll just do this one real quick and then.
Yep. We gotta do two more on that
then
same
we'll be
one.
done.
Not with that one, we're not.
Well, not with this one.
Correct.
Okay,
So you gotta do your, you were on Evans to do your fines and costs.
All right, the court will call Benji. What's that? Case number 2419695, that's set for hearing at 3:45. Neither party has appeared for that. It looks like we had a hearing back in August by Zoom. And then I set this in person, so I'm guessing that connection. Oh, I think they are here. You're all right. Luther, you can come right forward, please. Yeah, Mr. Rose.
Yeah, closing out, Judge. Just finishing my notes.
We're gonna give you a spot at that table unless you don't mind sitting at that table. It's up to you. Okay. You folks tell me how to pronounce your last name?
Dingy.
Dingy. Okay. So we're on the record in Dingy versus Dingy. Again, case number 2419695. Both parties are present here today in the courtroom. This is a matter that's set for hearing today. Mr. Dingy.
It just, we had a pretrial hearing and it just said plaintiff was having trouble connecting and the court set it for an in-person.
Okay.
It was a pretrial hearing. It was scheduled in August.
Oh, great. All right. I just needed to remind myself what happened last time. A lot of cases in 3 different counties. The question that I have for today, this is a scheduling conference where normally I would try to determine whether there are issues in terms of dividing up any assets or debts of the marriage, or whether the two of you had been able to reach any agreements as to those things. Mr. Dingy, you're the filing party in this case. Are there issues still remaining for the court to decide?
Nope, everything's all taken care of. The only thing I want her to do is go back to her maiden name.
Okay.
That's all I want.
Ms. Dingy, would you agree that there aren't any issues with regard to dividing up any property or debts?
Everything's good.
Do we have any judgment forms?
No, they're old. Yeah, they're old.
Do you have any objections to
We might.
changing your last name?
No, I do not.
Let me look, sir. I might have. If you give me just a second, I certainly can. Packets. Judgment. Let me see. I can run downstairs and maybe happy to run downstairs. I just can't print it right here.
Okay.
Yeah, I'll run down and get it right now.
So there's a final form that I need you both to fill out. It's called the judgment of divorce. It's what the divorce. Do you both want to do that today if you can?
Yeah, please.
Okay. So Mr. Fighter here is going to grab a form for you. I'll have both of you fill that out. Once you're done filling it out, let the clerk know. I'll come back out. I've got to take some brief testimony from both of you to establish the grounds for divorce, and then I can sign it and we can be done today.
Okay.
So you can just wait a few more minutes. We'll get things going. Okay, we're back on the record. If I could have you both raise your right hands, please. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Okay, again, I've got some questions that I need to ask each of you, and these are the questions I'm required to ask to establish the grounds for divorce. Mr. Dingy, you filed a complaint for divorce in this case, and you signed that complaint. Is that true?
Yes,
At the time that you signed that complaint, had you been a resident of Otsego County for at least 10 days?
yes,
Had you been a resident of the state of Michigan for at least 180 days?
Yep.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you signed the complaint?
yes,
Does that remain true today?
yes,
Are there any children who are under the age of 18 that were born to or adopted by you during the marriage?
no,
Under the proposed judgment of divorce, it indicates that you don't own any real estate or real property with Ms. Dingy. Is that correct?
yes,
It also indicates that you would not be receiving any spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
yes,
And as we indicated earlier in the hearing, already divided up any property or debts between the two of you, and there remain no issues for the court to decide. Is that correct?
yes,
Ms. Dingy, have you heard all the questions that I asked?
Yes,
Have you heard all the answers that he gave?
yes, I did.
Do you have any reason to believe that any of his answers were untrue? Are you currently pregnant? You are also not going to receive any spousal support under this judgment of divorce. You understand that you also would be waiving that forever, and that you would not be able to come back later and ask the court for that. And do you agree that you divided up all the assets and debts of the marriage with Mr. Dingy, and that there remain no issues for the court to decide?
Yes.
The court finds that the statutory grounds for divorce have been met by the testimony of both parties. I'm signing this judgment with today's date on Ms. Dingy because your last name is going to be changed. It is legally changed from today forward since I've signed the judgment of divorce.
Okay.
So, and you can probably get a copy of this downstairs before you leave here today, but you may need that to change your identification and other documents. Mr. Dingy, did you have any questions?
no, sir.
Ms. Dingy, did you have questions? Okay, thank you. That's all for today. That concludes the court's docket for the day. The court will be in recess until 9 a.m.